Hello everyone, and welcome to this webinar on furloughing in the early years. Before we start, please could you confirm that you can hear me by just typing yes into the question box. I'll just wait for a response. Yes, okay, quite a few yeses there, that's great. So essentially, in terms of this session today, we're providing guidance only, and delegates must take obviously legal advice and follow government guidance carefully. Our members, of course, do have access to our free legal advice service, Law Call. So in terms of presenters today, my name is Paul Donaldson. I'm the Director of Human Resources for the Early Years Alliance, and I'm going to ask my colleagues to introduce themselves.
Mandip, do you want to go first?
Yeah, I'm happy to go first. Hello, my name is Mandip Sanghera, and I'm the Legal Advice and Review Centre Manager for EPOC. And essentially, we provide legal services to lots of industries, and we provide the Law Call service to Early Years Alliance. So we're on hand 24 hours a day to provide you with legal advice.
Okay.
Thank
I'm
you.
Neil Leitch. Sorry, Paul, shall I fire away?
Yeah, please do.
I'm Neil Leitch. I'm the Chief Executive of the Early Years Alliance. My background was in finance, but I've been with the Alliance for certainly over 15 years now, so probably reasonably engrossed in early years as such. Been busy in the last few months, to say the least, with furlough and the fallout of furlough and all the consequences of what we were led to believe to be the case and what turned out to be reality. So I'm interested particularly today to see some of the challenges that colleagues might have. So here predominantly in a listening mode to see what we can do to support.
And I will also just ask Neil, after I've gone through my presentation, just to briefly tell us about some of the representations he has made to government officials and departments. I'm going to briefly summarise basically the coronavirus job retention scheme extension details relating to furlough, and we have received a large number of questions, so thank you for kindly sending those in advance, and Mandip is going to address the questions that we have received, and if there is time, we'll also pick up any questions that come in today. If we're not able to deal with any questions received today, then we will upload the responses to our website. So in terms of a brief overview of the scheme, obviously it was launched in March with employers being able to claim up to 80%, again capped at 2,500, and obviously employers could also claim national insurance and pension contributions. Obviously, employers can choose to top up to 100%, and whether the payment is capped at 80 for the employee will depend on the contractual arrangements in place or any agreements that are in place. Initially, we were told by the DfE, and I think many local authorities, and I recall having lots of conversations with Mandip about this, but we were told that settings could claim early years funding and furlough payments without any limitations. Obviously, further guidance that was issued subsequently has clarified that that's not the case, and Mandip is going to cover this point in a bit more detail, because I know that there's been a number of questions on this. The other element was the real-time information submissions, again, following, I think, some updated guidance on the 15th of April. We were told that employees needed to be on the payroll before the 19th of March instead of the 28th of February, and that information should have been submitted as part of the RTI submission by the 19th of March. And I think the general feeling is that this has severely restricted the numbers that benefit also. Again, we know that employees cannot work when furloughed, but we can encourage staff to undertake training whilst on furlough leave. And I think that's probably a really good use of their time, particularly in terms of mental health and well-being. And then the other issue, and I think this wasn't clear initially, but I think, again, subsequent guidance was that there was a minimum 3-week furlough period. And I know that some settings have made use of this by having or using kind of rotating furlough, using 3 or 4 week periods. Annual leave, again, I think this wasn't clear initially, but I think subsequently guidance was issued that basically confirmed that employers can require staff to take annual leave whilst on furlough. Essentially, to apply this, an employer would need to provide twice the amount of notice in relation to the amount of leave that staff are required to take. And then just the other point I wanted to highlight is that there is a need to keep records for five years. And I think this really does suggest that HMRC will carry out audits at a later stage. So all furlough records, its letters, paperwork, etc., should be kept for this time period. So again, this is not an exhaustive list of all of the issues, just a summary of a few points that I decided to pick out. And then the Chancellor announced on the 12th of May that the job retention scheme would be extended for 4 months until the end of October. During his announcement, basically explained that from August to October, the scheme would continue, but with greater flexibility to support the transition back to work. So this, I think that in particular, this has been one of the challenges for settings and employers. The kind of all or nothing furlough really hasn't worked effectively for organisations. So for June and July, sorry, what I should say is that details regarding the changes were published on the 29th of May, but further guidance will follow. So for June and July, the government will continue to pay 80% capped at 2,500, as well as employers' national insurance and pension contributions. So employers will be required to make any contribution to the 80% level at this stage. Sorry, employers will not be required to make any contribution at this stage. So then, from the 30th of June, the scheme will be closed to new entrants. So basically, the last day employers can place employees on furlough leave is the 10th of June. And then from the 1st of July, basically flexible furlough will start. And that means that employers will be able to decide and certainly agree for staff to work part-time. So again, the government will continue to pay up to the 80% cap, 8% capped at 2,500, and employers will be required to pay employees for the time that they work. So the government will not pay the period where employees are working. And again, employers are free to agree working arrangements. So that's any time, any kind of shift pattern. Again, this will be determined by the employer, again, in conjunction with the usual conversations with employees. And a really important point just to note here as well is that where there are these arrangements in place, that they should be agreed in writing so that there is a clear record going forward. And again, at a later stage, the HMRC obviously may want to look at all of the evidence. So then from the 1st of October, the government will pay 80% of the wages up to the cap, that's 2,500. And then employers will now pay the employer's national insurance and pension contributions. So that means employers can no longer reclaim the NI and pension contributions through the scheme. So then in September, the government will cover up to 70% of a furloughed employee's wages, again up to a cap, that would be 2,187. And the employer will be required to pay and make up the wages to the 10%. And then from the 1st of October, it changes to 60%, capped at 1,875. And again, the employers makes the 20% contribution. So what I'm going to do is just move, because that's probably quite complicated. In the government's guidance, they have produced this chart that I think probably sets it out a bit more clearly. So in terms of the government's contribution, employers' NI and pension, the government will contribute in July, but will not contribute in August, September and October, and that's on employers' NI and pension contributions. And then in terms of wages, the government's contribution, so 80% in July, 80% August, 70% September, 60% in October, with the caps changing. And then so employers' contribution in terms of wages, so 10% in September, 20% in October, again up to the relevant caps. And then throughout each month, the employee receives 80% up to the cap, 2,500. So hopefully that chart explains it a bit more clearly. Just a couple of other points, and that's on the 31st of October, the scheme ends. So that essentially means that employers will no longer be able to make a claim after this date. And the guidance also talks about a minimum furlough period of 1 week as well. So that's new. And then we've also been told, or certainly on the government's website, there's a note that states that guidance on flexible furloughing and claim calculations will be provided on the 12th of June. Again, for settings that are in receipt of the early years funding, obviously the claim calculations are going to be an important part of calculating kind of part-time furlough. Just a few other points in terms of the 80%, again, just to reiterate that really that whether the employer chooses to top up to 100% will be based on obviously the contract and any agreement in place. So paying less than 100% and 80% would be subject to those arrangements already in place. So I think that's a very brief overview of the scheme. What I would like to do, Neil, is just to ask you just to tell us briefly about some of the representations that you've made to government officials and departments about the scheme and the impact on the sector.
Yeah, of course. Without harping back on old ground, but it is important because I think it sets the scene for what our asks might be moving forward. I'm sure everybody will recall that at the outset, we were led to believe that we could access both the dedicated schools grant, i.e. the free entitlement funding, and the furlough scheme. There were, at that particular point, when we were told that was the case, there were no caveats. Nobody said it would be subject to a reduction or prorated, full stop. At that particular point in time, I have to say that the Alliance was also aware of some personal comments that were coming forward from Treasury, coming to us directly, so we couldn't put them into the public domain, that sort of alluded to the fact that that wasn't actually going to be the case. So having known all that, we quite rightly and we took some criticism for this. But as I say, colleagues did not know, were unaware that we were being fed this information from Treasury, saying it won't be quite as rosy as your members think it's going to be. So we sought clarity from the Department for Education right from the second day, saying, have we got access to both these funds? And every day that went by till almost a month had passed, they just said, just reiterate to your members what's in the guidance, which again alluded to no caveats, we could just get funding. And then, as you will all be aware, at the 11th hour, we were told, actually, what you have to do is net off your income from the free entitlement and do things on a proportional basis. And the reason I think that is relevant is because we've just done some fairly large scale surveys, and something like 3,000 providers in terms of one survey have come back to us. And they told us that 75% of those respondents took decisions about what they would pay their staff, what staff they would retain, what staff they might furlough, on the basis that they believed they could get access to both funding streams. And then probably more importantly, I guess, in terms of concern, 45% of providers said that they felt they would now have to make people redundant as a result of misleading information. So, you know, in terms of people's lives, this was quite critical, quite important. So, of course, what we've done to try and bring this up to date, and this is the relevance really, is to continually quote that. In fact, I was on the phone this morning to a Baroness in the House of Lords who is going to be asking questions because she was unaware that we were misled in this particular area. So she will be asking key questions and supplementary questions backed by other Lords colleagues to try and get the issue raised again, and in particular to try and get some compensation by way of transitional funding. And when I say transitional funding, the fact that many nurseries have opened their doors, we estimate at the moment there's about 2/3 of nurseries opened or will open close to the 1st of June. And of course, what happened there is that you had, as I say, 2/3 of providers open, but you only had on average around sort of 45–46% of children back through the door, which means you have disproportionate costs, disproportionate staff costs, because you have to be concerned with health and safety, transmission concerns, social distancing, and yet you have a fraction of the revenue coming in. So somehow they've only just woken up to this, and so they will be lobbying to try and get some compensation. We, of course, have done the same thing. We've written to Treasury, the Chancellor, to the ministers several weeks ago, putting forward alternative proposals for transitional funding. But it might be the fact that it's quite clear to me that the Department for Education, and in my opinion, ministers recognise they messed up big time. That might just give us a little bit of leeway to try and get some interim funding as those sort of rates, the 10%, the 20% rate, the increase in the national insurance in terms of our contribution comes into play. And it's also fair to say that several employers paid 100% throughout this interim period, thinking they would get access to both funds at the outset. That, of course, may well change now. And so that's why I think it's quite important. But hopefully that gives you some indication of the fact that we haven't forgotten this and we are not giving up on this, and we will be pushing this all the way through in terms of trying to support the sector. It's probably all I could say at this particular point in time, Paul, hopefully that's helpful. If Paul's still with us.
I'm sure he is.
Paul, are you on mute or?
Shall I just move on to the questions that we received? Yeah.
You have some of the questions there, I assume, yeah?
Oh yeah, we had quite a few pages of questions that have come in. So what I've done is I've tried to put them into broad categories so we can discuss them during this webinar. I won't be able to discuss specifics, but I'm going to give you a broad amount of information. Obviously, if you want specific advice, then you really should call the law call service, and then we can go through all the nuances and make sure that you are getting the right advice. But what I'm going to start with is to discuss sort of furloughing, and we had quite a few questions on how we work out furloughing, because obviously there was so much information on, you know, you can furlough, you can't furlough, and how much you can furlough and what's going to be available. I think as a service, we were constantly on the back foot, having to quickly read the guidance that was coming out, and then, you know, having to interpret it for members. And I think that's going to continue to happen when there'll be further guidance that is it's put forward on the 12th of June. So, you know, things may change in terms of the advice. So as it stands now, if you're going to furlough employees, you have to meet certain conditions. And there are a number of conditions. The employee works in an area of business where the services are temporarily not required and their salary is not covered by public funding. They would have otherwise been made redundant or laid off. And this employee can't be involved in delivering provisions that have already been funded. So it's the free entitlement funding. And where appropriate, they're not required to deliver a provision for a child of a critical worker or a vulnerable child. So essentially, they're not working within the setting for key worker children. Also, and most importantly, the grant from the Coronavirus Job Retention Scheme wouldn't duplicate any other public grants received. So what the government were really concerned about is that it wouldn't lead to financial reserves being created, which is why this guidance has essentially come out. So the starting point is really to look at the income that you receive in February. February is the key date, essentially. So I'm going to give you a few examples to put this into context. If a provider receives £10,000 of income, of which £8,000 is received from public funding and £2,000 from private funding, then essentially they've got an 80-20 split. So 80% is from government funding and 20% from their other income. So then what they need to do is look at their pay bill. And then once they look at that, then they would then furlough 20% of those employees that cover their pay bill. So to simplify this, if you had 10 employees and you received 80% funding from the government, you would be able to furlough 2 members of staff, because that's essentially would equate to 20% of your pay bill. But the most important thing to remember is that the starting point is February, but your funding may change in subsequent months. So, you know, it may change as a consequence of you receiving greater funding because the local authorities have seen that you're dealing with more key worker children, so you'll get more funding, or there may be a reduction in funding, and that could be for numerous reasons, such as the information that you gave to the local authority showed that you were going to get less children in this particular, you know, the next term. So you have to keep recalculating the amount that you're receiving in terms of funding, and you have to look at it as a percentage of your total income. So if they reduced your funding by 10%, then your government funding would be 90%. So in effect, you would have to take 1 employee off furlough and bring them back into the workplace, or you would essentially have to pay them from your funding. Again, if you receive less funding, then you could furlough another member of staff. But what's really important is that you can only furlough a whole member of staff. It has to cover an entire staff member. You can't furlough a percentage of an employee. So, for example, if you receive 92% funding, you can't then furlough 2% of a role. It has to be particular roles, particular employees that need to be furloughed. So there were quite a few questions on how it's calculated. It can be a little bit complex, but it is by looking at the percentage of funding that you receive and then looking at your pay bill for February. What you can't do is to change the amount of funding that you may have received from parents. The parents' funding is always calculated on the February, on what you received from parents in February. So the other income, you know, even if you think that that income was going to go down in subsequent months because you didn't have as many children, you can't recalculate that. It's always based on the funding that you receive from the government. So Paul's already discussed the changes that are going to happen from the 1st of July. So what I'm going to move to next is that there was quite a few questions on reopening. So I think really the key points, a lot of you will have already reopened or have been open for key workers' children, but we've also had quite a few members that have phoned in and said that they're going to look to open in the next couple of weeks. So it's really important that you look at the guidance that's published by the DfE and you follow the guidance in terms of premises and risk assessment. But what's also really important is that you can still carry out your own risk assessment because it's your responsibility. And that may be in relation to individuals that are in the setting that may be clinically vulnerable. So that is really important that that needs to be done. So most settings carried out an audit to assess how many children would be returning to their settings, to work out how many staff members they'd require. And that, in certain circumstances, led settings to reduce the number of hours that they required employees to work. So a lot of questions are centering around, well, how can I reduce these employees' hours? And really the starting point is to look at your contracts and what happens in custom and practice. So a lot of settings do regularly change the hours that employees work on a termly basis because of the increase or decrease in the number of children that you have in the setting. So you might have the variation clause, which is something along the lines of the number of hours that you work will vary if the number of children in the setting reduce or increase. Something similar to those lines. If you're unsure, then please give the service a call. And also, you may also want to rely on a short-term working clause because in terms of layoff, the Early Years Alliance have a standard clause in their contracts which talks about short-term working and layoff. So layoff is when there is no work available, and short-term working is where there's a reduction. So those sort of clauses you need to look at to see if you can reduce employees' hours as well. But not all settings have these sort of clauses in their contracts of employment. So if you don't have these sort of clauses, then really what you need to do is you need to sit down and you need to start consulting with your staff and see if you can agree a short-term variation of their contract. So if you can explain to them what your financial difficulties are, this is going to be a short-term measure, this is what the reduction is going to be, and you need to see. It's quite difficult because it's not necessarily, sometimes you're not going to have the same reduction in hours for each member of staff. If you can reduce it equally amongst all of your staff, then that's absolutely fine. But sometimes it doesn't always work when you're working with ratios and you need your managers in and you need deputies in at the same time. So really, you need to look at it across the board. And if you're unsure, again, give the law call service a call and then we can go through this with you. So if you can agree a short-term variation, either through a clause that you've got in your contracts or by agreement with the staff, then that really needs to be followed up in writing and confirmed. If you can't reach an agreement with the staff, then potentially you would have to consider redundancies. And it may be that you have to consider reducing your staffing levels, and again that has to be done fairly, and that's really important that you follow a fair process when you're dealing with redundancies, because you don't want employees bringing a claim if you've not consulted with them, if you haven't selected the employees fairly in relation to an objective criteria. You can't discriminate in relation to the criteria that you use, and this is really quite important because when we're talking about discrimination and redundancy, you just have to be really careful if you've got clinically vulnerable members of staff or vulnerable members of staff because they have pre-existing conditions, and that's the reason that they can't work. So that's the sort of questions that we're getting in terms of reduction of staff and the sort of the key questions on can we reduce the number of hours that they work. And this really in turn is leading to a lot of questions about employees who are reluctant to return to work. And that's probably the most frequently asked question that we've had in the last couple of weeks. And this is probably going to be the most difficult situation that you'll deal with as a setting. And really, it's fundamentally important that we communicate with staff and address any concerns that they may have about returning to work, explaining what measures that you put in place to protect them and any children returning to the setting. Now, there are certain categories of employee that are afforded special protection. So if a staff member is clinically extremely vulnerable and And that to you and me means self-shielding. So a self-shielding employee, we get a lot of employees that have told settings that they are self-shielding, when in reality, they're not quite sure what that means. So if you're clinically extremely vulnerable, then you will have received a letter from your doctor or from the hospital, and they will tell the staff members that they are supposed to isolate for 12 weeks. So if they've received one of those letters, and you can ask for the evidence, then those sort of employees are advised not to attend the setting. If you're unsure what clinically vulnerable, extremely vulnerable members of staff are, whether or not they fall within the category, the information is there on the guidance that's published by the DfE on getting settings reopened. So then you've got a slightly different category, which is clinically vulnerable individuals, and it's not exactly the same as self-shielding. So these are individuals that are at higher risk of severe illness. So they're generally people that have a pre-existing condition which makes them more susceptible to, suffering, some more severe symptoms. And the guidance that's been provided is that you need to take extra care. And these employees need to observe social distancing. So whilst they can return to work, the question really is can they observe social distancing? And if they can't, then you should see if they can work from home. The same with the clinically extremely vulnerable staff. If you've got work for them, then that's fine. But this also includes pregnant women. They fall within the category of clinically vulnerable individuals. And the question really is whether or not they can socially distance within the setting. So you may be able to put in place some measures. They may be able to work in the office, provided that they're able to socially distance, keep 2 meters apart. That doesn't necessarily mean that, they may not be able to interact with the children, because they're not going to be able to necessarily maintain that social distance. So those are things that you have to consider. That's why you have to carry out individual risk assessments. So essentially, employees that are clinically extremely vulnerable, they're eligible for SSP payments. So you don't necessarily have to furlough those members of staff. You can pay them statutory sick pay. Now, the other point that a lot of employees are arguing is that they live with someone that is clinically vulnerable. So if they live with someone that is clinically vulnerable, including those that are pregnant, they can come into work. And you just have to make sure that the same measures that you've put in place for all your employees apply to these employees. It's slightly different for a member of staff who lives with someone that is extremely clinically vulnerable, and they've been told to self-shield. So they can only attend if stringent social distancing can be adhered to, and if it cannot, they should be supported to work at home. And that really sort of turns to the sort of other questions that we get. When do we pay SSP? So SSP is paid in a number of circumstances. So if an employee has coronavirus, if they have the symptoms, a high temperature, new continuous cough, or loss of or change in the sense of smell or taste, or if someone in their household has coronavirus symptoms. So if they do, then they're entitled to SSP, and for the first 14 days, then you can reclaim that back. Now, if they've been told to shield because they are clinically extremely vulnerable because of the underlying health condition, then they're entitled to receive SSP. Or if they've been told to self-isolate by a doctor or NHS 111. So those may be circumstances where you've got a pregnant employee. So if a pregnant employee is saying they don't want to come into work, or someone that is clinically vulnerable because they may have an underlying condition such as diabetes, if they can provide you with a fit note from the GP or NHS 111 saying that they can't come into work, then they may be entitled to SSP. And finally, if they've been told to self-isolate by the government test and track service because they've been in close contact with someone, again, they will be entitled to receive SSP. But if you're unsure, my advice is to give the law call service a call. So a lot of issues may also arise because staff may explain that they don't have childcare, and they don't have anyone to look after their children. And so what we would do is we would gently remind them that they are key workers and their children are entitled to go to school. We have to also understand that these employees are probably a little bit fearful about coming into work, so we have to again demonstrate what steps we've taken to protect them, and in turn that will mean that they're not going to be passing on anything to any member of their household. So it isn't an easy issue to deal with, especially when you've got employees that don't want to come back to work and they've got no reasonable explanation for failing to return. So if they don't have a reasonable excuse, you've really got to explain that they are needed to attend work. And if they're not able to attend work, well, strictly in legal terms, then their absence would be unauthorised. But given the circumstances, I think tribunals wouldn't look on that, view that employers dismissing employees in these sort of circumstances, they may feel that that's unfair. So you may want to consider advising those employees that, well, if they can't come into work, then strictly they should be taking unpaid leave. But if you want to consider dismissing an employee in those sort of circumstances, my advice is always to take advice first, because we have to explore all of the circumstances. We shouldn't just simply say, if you're not coming into work, then we're going to terminate your employment. A fair process also has to be followed, but we also have to have regard to the fact that we are living in very difficult circumstances at this moment in time, and it is very difficult for all employers and employees. So we should be willing to listen to the employees to explore what their reasons are for not wanting to return to work. So hopefully I've answered all of those questions, sort of dealing with, returning to work, reducing hours, and how to deal with staff. Now, we've also had quite a few questions on a number of settings that have asked about, well, what happens in the summer term? We don't receive funding in the summer term, so what happens? Can we furlough staff? So a large number of settings only operate 38 weeks of the year and close after the summer term. So the question of whether or not you can furlough employees during that period is quite complex, because first you have to consider whether this is a period in which you would normally pay your staff. If it isn't, then the argument is that you can't claim under the furlough scheme because they wouldn't normally be paid. Other settings may place their staff on annual leave during sort of July and August. So if they get paid annual leave during that period, then technically they could be furloughed, provided that you topped up their salaries to 100%, because that's, they're on annual leave and they're entitled to receive full salary during that period. But, and this is a very big but, this is subject to the proviso that you can only furlough employees that have previously been furloughed on or before the 10th of June. So effectively, this means that it would only be the proportion for the employees that you've received private funding for. You cannot then later increase the number of staff that you want to place on furlough during the summer to reflect that you're not receiving any funding during the summer period. Obviously, this has to be caveated because, the Early Years Alliance are going to ask questions of the Treasury and the DFE in relation to term time settings. Other questions that we're receiving are, we're a term time only setting and staff are paid by 12 monthly instalments. And the question is, can we then furlough those staff? Well, if they would normally receive a payment during the months of July, the rest of July and August, then again, you could furlough those staff. But again, this is only on the basis that you can furlough staff that were previously furloughed on or before the 10th of June. So if you had 10 staff members, for example, and you were furloughing 2, you can still claim furlough for 2 of those staff members, but not any additional staff members. So it is quite complex, and when we deal with settings, we tend to find that not every setting deals with annual leave in the same way. Some settings don't actually set out when employees are due to take annual leave. So it's a question of whether or not we could say, well, we are now going to serve them with a notice to say their annual leave is actually going to be in August. So we can, take the benefit of some possible furlough payments. But also when we look at the 12-month instalments, hopefully most settings will have had some reserves to meet these payments, because essentially you've been paying the staff less over the preceding, the previous month. So there should be some funds available to pay those staff members. And I think I have covered all of the questions that we received. So,
okay,
we've still got 20 minutes.
Yeah, no, that we have received some more questions. Just before I put those to you, Mandip, I just wanted to emphasise the point about the number of employees an employer can claim for cannot exceed the maximum number that they've claimed for in any previous claim period. So really, just I think that's a point that settings will also clearly need to be mindful of.
Yeah, absolutely. That's what I'm trying to emphasise. It's sometimes quite difficult to do over a webinar, and especially when not everyone's circumstances are the same. So, if you're unsure, then please call the law call service for advice, and we're happy to go through that.
And then some of the additional questions are, so the first one is the pay bill the total of furloughed and unfurloughed staff salary for the month?
Is the pay bill the total
of furloughed and unfurloughed staff salary for the month?
Okay, the pay bill should be whatever your normal pay bill is in February. So your staff wouldn't have been furloughed in February, so you'd look at what your pay bill was in February, what you paid out in actual salary to your members of staff. And then once you've got that figure, you would then work out the percentages of, so if you received 80% funding, then 20% of that payroll bill that you had in February is what you can use to furlough. That is the amount of money in a percentage that you can use in terms of furloughing. So it's only 20% of your payroll costs for the purpose of furloughing staff members. Does that make sense?
Yeah, thank you. Another question, are we to change future furlough claims in relation to changes from new terms starting in April, or do we continue using February figures? So essentially, figures may change in April, but do we continue to use the February payroll data?
Not necessarily. So if in April your government funding increases or decreases, then you have to change your calculation accordingly. So if your funding stays the same, then you still use February's pay bill as your starting point. You only recalculate if your funding changes in subsequent months. So if you receive, for example, 10% more than you would normally receive, that means that you have to take a member of staff off furlough. If you receive less, you may be able to put an additional member of staff on furlough that previously wasn't on furlough.
So is that in relation to the amount of early years funding received? What about in terms of the basis of calculating staff pay?
So are we talking about, I'm not quite sure what the question is actually trying to deal with. If we're talking about, so for example, if you received an additional 10% funding, so yeah, you look at your February pay bill, and if you then received an additional amount of funding in April, then that would reduce, you look to see what your pay bill would have been. Let me just check a point. I'm just going to go onto my guidance that I've got open here, and I'm just going to check that point. Bear with me a moment.
Yeah, so another question has come up again. Do we base furlough on February only or subsequent months?
Okay, yeah. If I go to the specific guidance, which I'm on now, sector specific guidance. So what it says is that if a provider's average monthly income is 40% from government funding and 60% from other income, the provider could claim support for 60% of their pay bill, because that's the other income. These proportions could change in subsequent furlough applications as a result of public funding changing, but not where income from parents increased or decreased. So if the provider subsequently receives additional public funding from the local authority because of, for example, providing additional hours, then as such its new funding would represent 55% of its total income in February. So yes, it's the February income that you're still looking at, but you would then just calculate whether or not the proportion that you're using is increasing or decreasing. So you always look at the month of February pay bill.
Right, okay, yeah. Another query was around, is it just pay bill and funding? What about fundraising? Does that have an influence in the calculation?
No, my understanding is that it wouldn't have an influence. One, because you can't determine what you're going to receive through fundraising. So it's not income that you would be able to demonstrate that you will get, unless you receive that income in February. Then if you receive that income in February, then you could say, well, that's part and parcel of the income that you received in February. But if you're trying to rely on fundraising that you may have had in subsequent months, like a lot of settings fundraising in the summer term, you can't then say, well, we would have received, more funding from parents in, other months. So that means that, we want to increase the number of staff that we can furlough, because that is not certain. There's no certainty as to how much fundraising we would have received. So my advice is that fundraising wouldn't be calculated within that. And I have not seen anything in the guidance which would suggest that we would be allowed to pop that in.
Yeah, okay, thank you. I think you've clarified this one. It says, if furloughed staff have to take annual leave, do they get topped up to 100% or can they get the 80%? So I presume that this person is paying staff at 80% of their furlough. So if they require staff to take annual leave or staff take annual leave, at what rate should they pay their staff?
It should be their normal rate because it's annual leave, so that has to be topped up to 100%.
Okay, thank you.
Which may be a little bit more difficult if you've got settings which are paid over 12 months, but then you'd have to look at the way in which that is calculated. And that's probably a specific call that needs to be made to us.
This question deals with, so if the last day of furlough is the 10th of June to place a staff member on furloughs, is that the last day I can physically do it, or the last day I can claim for?
I think we have to wait till the guidance comes out, but I think you would place them on furlough on the 10th of June, and then you would make the real-time claim. The difficulty is I wouldn't want to say without the guidance coming out. There could be the argument both ways. They could argue that no, the real-time sort of payment through payroll has to be done on the 10th of June, or they could say that no, you just have to place them on furlough by writing to them and advising that they're on furlough, and then you can actually make the claim at the end of June. But I can't tell you what. Mm-hmm.
Yeah, but we know that actually the real RTI submissions previously, the guidance was slightly changed. So I think you're right in saying the guidance comes out on the 12th of June, and I believe it will specifically look at the arrangements regarding to flexible furlough and the calculating claims as well. So we probably do need to wait for the guidance.
Yeah.
But again, the 10th of June is the last day for new employees. So if you've never put, if you haven't claimed for someone previously, then after that date you will not be able to claim for that individual.
Yeah, so if there are settings out there that just simply haven't bothered claiming furlough, but they do have a percentage of their payroll bill which is attributable to parents' fees, then they might want to consider doing that. What you can't do is furlough more employees than you're entitled to in terms of eligibility of funding and parental income. So you can't just simply add employees on if it means that you'd be breaching the guidance. But if you've never claimed and you can claim and you meet all the conditions under the rules, then you may want to consider doing it now.
And then the next question: can the employer still top up to 100%? I presume this is during the extended period.
There's no reason why an employer can't top up wages. The furloughing is just the minimum that you have to pay an employee. So, if you have the income to do so, then yes, you can top up, but you have to be really careful if you're a charitable setting that you don't eat into your reserves in terms of if there were any future issues concerning redundancy and notice pay and things like that. So yes, if you have the funds to top up, then most certainly you can do so, but you just need to be careful that you're not dipping into any reserves that you need at a future date.
Okay, thank you. Another question: I need to bring my employee back part-time from next week. Is my only option to unfurlough her completely, and then I won't be able to furlough her again after that, so we'll have to pay her 100% of her wages from next week?
Well, the first thing to look at is if you do bring an employee back part-time, then no, you can't claim at the present time any furlough, because that only comes into effect on the 1st of July. So if you're reducing their hours, the first thing you need to look at to see is whether or not the employee is agreeable to a reduction in their hours, because if they are, then you don't necessarily have to pay them 100% of their wages. Also, in July, we also need to have a look at the wording of the guidance to see whether or not employees that are already been put back to work that were previously on furlough, whether or not you can then claim for a proportion of their income in July. But that is dependent on how the guidance is worded, because it may well be that the July changes are only going to be relevant for employees that were immediately on furlough before the 1st of July. So again, we need to, the devil is in the detail, unfortunately. We need to see what the guidance states. So the fact that we're bringing someone back part-time, really, we don't necessarily need to pay them full-time wages if there is a contractual clause which allows us to reduce their hours. So that's what needs to be explored for that particular setting.
Right, okay, thank you. I think this might be one for Neil, but basically it's that backtracking that is making me unsettled as a charity nursery trustee, as whether we'll be allowed to continue to get enough help via the job retention scheme going forward, and we can't believe the guidance. I mean, certainly one of the challenges around the guidance is that because it changed, because additional guidance was released over a period of time, it led to different interpretations, and in some cases where people felt that they were able to claim a certain amount of money, or people were eligible, it transpired that they weren't. So I think probably the kind of slowly releasing of guidance incrementally, I think has been a real challenge for everyone. I don't know if you want to add to that, Neil, because I know that those are some of the conversations you've had with government departments and officials.
Yeah, I think it comes back to the initial point that, this was so poorly managed, and if ministers had no idea of how it was going to operate, then we within the sector certainly couldn't have forecast what was about to happen. But the harsh reality is that the Chancellor, of course, will be looking at this across every sector. And whilst, of course, it is important to us, when you look at the overall number of people that are on furlough, when you look at the challenges that the Chancellor will look at in terms of retail, hospitality, etc., they won't feel our pain. And he won't have the history. I mean, unlike many retail and hospitality outlets, we have a history of being underfunded, but that of course won't appear in the horizons. And I guess that's the argument as to why we keep pressing for this, if you like, transition funding. If the minister had within her give to undo all this and to put a pot of money on the table and say, look, we messed up big time here, I get the feeling that they would do that. They know that they've erred. They know that they've misled the sector. And so the only thing that we can do, but I don't think, having said all that, that early years is top of the agenda. When you listen to all the rhetoric, it's schools, 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 and we seem to be an afterthought. And so, I've made the comment in several, whether it's radio or TV interviews, if you've got 1 children returning to your setting or 100, if you're a school, you don't really care because you are paid. Your bills are paid for you. That is not the case when it comes to early years. And so I think that they recognise the situation. Certainly the Department for Education does. It's whether they have the power within the overall economy to make the argument. But certainly we can't let go of that. We have to keep focusing in on this injustice. And for all the reasons I said at the outset, I think we just have to treat it as almost an Achilles heel and just keep banging at that. In the meantime, regretfully, people are going by the wayside. I spent last week speaking to several nurseries, one that had been in existence for 51 years. The proprietor was 80 years of age. Of course, other colleagues were operating the nursery as well. She was now having to close. Another one of 28 years, serving their communities, having to close. And so in the meantime, of course, people go by the wayside. So I'm afraid I don't have a magic wand and I can't give you any consolation. But what I can do is agree with you that this has been an appalling handling, particularly for the early years.
Right, thank you very much, Neil. We're almost out of time, so what I might do is just to pick up on 1 or 2 more questions, and then any questions that we're not able to deal with today, we will put into a Q&A and make those available on our website. So a couple more questions. In September, if our number of children is reduced as capacity continues to have to be lowered, can we furlough staff then? Do they have to be the same staff we furloughed in April?
My understanding would be that there have to be staff that were previously furloughed. Again,
Yeah,
we need to wait for the guidance to come out, but yes, that's my understanding. It has to be the same members of staff that were previously furloughed on or before the 10th of June.
Well, can I just add to that? Interestingly, I was in a conversation with the DFE today, and that was almost an identical question that was asked. And again, without them having hand to the guidance, and I know my colleagues will be thinking, well, why should we rely on anything that they say after what they've done recently? But they were quite clear that if you had not been furloughed, as at the 10th of June, you would not be eligible for funding. So I think that endorses everything that Mandip is saying there.
Okay, and should my setting be paying 80% to furloughed staff, or can they be paid a less percentage?
No, they can't. But sometimes settings don't use the word furlough when they're actually talking about short-term working, rather than, if we're talking about furloughing, then that is the job retention scheme, and that has to be paid at 80%. But we've had a lot of settings that interchangeably use the word furlough when they don't actually mean furlough. And that's something one of my colleagues said to me today. Can you please emphasize that furlough is the job retention scheme where you have to pay 80%? So yes, if they're being furloughed and you've sent them a furlough letter, you have to pay them 80%.
Right, okay. I think we are just out of time. So as I said earlier, what I will do is to make sure that we pull together a Q&A and put the remaining questions, make them available on our website. I would like the opportunity to thank Mandip for her time. So thank you very much, Mandip, for reviewing all of the questions and joining us today. What I will say, certainly for Alliance members, Mandip leads on, I think, a really excellent legal advice service. So for members, if you have individual questions or issues, please do ring our law call service. I'd also like to thank Neil Leitch as well, our CEO, and I know that he and communication colleagues continue to make representations on behalf of the sector. Certainly, you know, what seems to be an unfair system. So hopefully today you've enjoyed the session, and thank you very much, everyone, for your time. Thank you.
Thank you, Paul.
Thank you.